Hi, this is Ed Weinberg. I'm with CTRE Investors, and today we're talking with Kent Miller about new laws in Connecticut that affect landlords. We also have here Julie, who's got a problem with her audio, so we can't hear her. But I know she's listening, and I'm not sure who else is. And, if you're listening on Facebook, it would be nice if you could click on the like button or leave us a comment. If you've got a question, you can leave it as a comment, and we'll see it here. And Ken will be able to answer all your comments. So I have a funny sound problem, so I'm just putting in my headset when I'm not talking, because when I'm talking, I hear it in my ear. So give us some likes there. And Kent, why don't you give us an introduction? Tell me who you are. What do you do?
Yep, I'm Kent Miller. Hi, Sue. I'm an attorney in the greater Bridgeport area. My office is in Stratford, Connecticut. The law firm is the Miller Law Group, and I've been primarily practicing in the area of real estate litigation for the last 26 years. Today, I was admitted on Pearl Harbor Day in 1990. So after working for the Superior Court as a judge's research clerk for a year, I went into my own practice and have been in private practice ever since. I used to represent the FDIC, People's Bank, the city of Bridgeport, all in the area of landlord-tenant law and foreclosures and other types of real estate litigation.
All right. I'm Ed Weinberg. I'm a real estate agent and a real estate investor. I run a website called ctreinvestors.com, and this is also has an associated meetup group and an associated Facebook group. So, Kent, you want to tell us? You want to go in and tell us about these new laws?
Sure. As of October 1st this year, 2017, 4 new laws went into effect in Connecticut that have an effect on landlords. And some of them are major, some of them are not so critical, but we'll cover each of those this evening. The first item, and I'm going to go ahead and post the summary into the comment box here, but the first item is that now many people, if you've been renting for a long time, you know that you can only collect 1 month's rent for a security deposit if your tenant is 62 years old or older. Well, they just changed the law to say that in the event your tenant turns 62 after they started renting from you, they can now request one of the 2 months security deposit to be returned when they reach 62. So in short, landlords must reduce the security deposit being held to 1 month's rent upon request when a tenant turns 62.
Okay, so you must give it back to them if they ask for it, but if they turn 62 and they don't ask for it, do you have to give it back?
The law is silent on that, so that means that the request of the tenant is required.
Okay, so that's law number 1. And now, did they give us any kind of penalties that we might get if you don't follow that law?
Well, there are penalties built into the security deposit law already. And one of those is a doubling of the security deposit. So if you're obligated to return 1 month's security deposit, it's quite possible the court could impose punitive damages in the amount of 2 times the security deposit. Since this is a new law, we don't know whether that would be 2 times the 2 months or 2 times the 1 month you didn't return. Additionally, since you're required by law to return the security deposit if it's requested, retaining it could be considered larceny and you might have the possibility of criminal charges being brought against you.
Okay. So tell us about what other laws there are.
The next law that's critical is a law that changes the amount of time that you must provide substitute housing to a tenant who loses their essential services. So if you have a tenant and they lose their heat or their hot water or some other essential service, and they notify you, you used to have to repair that within 2 days, 2 business days, or the tenant could go and look for alternate housing and charge that cost to you. Now they've shortened that from 2 business days to 48 hours. So if you get a call late at night on a Friday from your tenant, you have until 48 hours on Sunday, not Tuesday as the law used to read.
Okay. Doesn't sound great for landlords.
No, that's not. So, you know, the important thing then is to maintain those critical services, hot water, gas, heat. Interestingly enough, and it should be noted, air conditioning is not an essential service, nor is cable TV. So if those are included as part of your rent and they go out, you have no obligation to provide those or replace them.
Okay. And hi, Sue. I see you asked a question. Where is Julie? Julie is still here, but she doesn't have, basically, Julie came on. She was going to introduce herself, and I'm kind of testing this out. This is our first live interview using this software. So Julie is here and she's listening, but she can't speak. So we're not showing her. But if you like, I can leave her up there, but then you have to keep smiling, Julie. Okay, that's good. All right. Go on, Kent. Let's go with law number 3.
The third change in the law is, this is probably the most important thing for people to be aware of, but it's probably the least likely to be violated by real estate investors, by professionals. You may have heard that there have been cases. One notable case, particularly involving a gentleman named Burke, who would contract to buy real estate on a short sale basis and promise the owner of the property that they would stop the foreclosure. Then they would lease it out to a new tenant, collect the rent, and never stop the foreclosure, so people would lose their homes. And this person would continue to collect rent even after the foreclosure was completed. This happened in the greater Bridgeport area and actually resulted in the reprimand, actually suspension, of a housing attorney who was working with him. So the law now says that if you collect rent and you do it after the law day has passed or after you otherwise have a legal right to do so, the penalties of larceny will be imposed. So larceny is a Class C misdemeanor all the way up to a Class B felony based upon the amount of the rent you're collecting. So if you collect 2 or 3 months of rent after the law day is passed, that income is technically the title owner's property, and that's why they're calling it larceny. And there was a question in the law about that previously, but now this statute has clarified that. And with any felony, you can be imprisoned for a year or more if you're found guilty.
All right. So let me just clarify here. If let's say that I own the property and I'm collecting rent. If I own the property and I'm collecting rent, I have to stop collecting rent, or this is only if I'm managing it for the owner?
This is anybody who collects rent that is not authorized by the owner of the property. So in a foreclosure, if there is a strict foreclosure, which is a foreclosure where title passes to the foreclosing party if a certain date passes, and that date is set by the court. Once that date passes, the property belongs to the foreclosing mortgage company or bank, and therefore at that point, nobody but the bank or foreclosing party is entitled to collect rent, unless they have authorization from the new owner. The time period for which that would happen in a foreclosure by sale would be when the title is passed to the new owner after the closing, after a foreclosure by sale.
Okay, so typically when we have a foreclosure by sale, we have a day where we show up at the property. In Connecticut, it's always noon on Saturday, so you can only go to 1. So I show up at somebody shows up at a sale, they are the successful bidder. Typically, that could take some amount of time, and it varies from house to house as to how long it takes for a court to actually approve that sale. Just because you won the sale doesn't mean that you get the sale. Is that correct?
That's correct. And in addition to that, even after the court approves the sale, there's still a couple of days, maybe a week or two, before the actual closing takes place, and it would be up until that closing takes place that the owner of the property could still continue to collect rent.
Okay, you were talking about the owner or someone who's managing it for the owner.
Correct.
So is it the owner or the person managing it that would be in trouble if they collected money after the title passed?
Well, the statute says the landlord, so it's possible that the agent would, if the agent is told to collect property and they don't know about the foreclosure, then it's possible that only the landlord would be held responsible, because that's what the statute says. However, this is the kind of a statute where I think it puts notice on property managers to make sure they're aware of when a foreclosure is commenced against property they manage and when title passes, because even without this statute, you could be subject to civil liability if you're collecting rent from a property that your principal does not own.
Okay.
The principal being the person asking you to collect the rent for them.
Sure, I understand. Okay. And there's one more law?
One more law. This is a little more complicated, and it's one of those laws that will work really great when it works, but it makes things a little more complicated when it doesn't work. So the thing that's changed is there's sometimes difficulty in being able to dispose of a tenant's property after they pass away. Previously, you would have to notify the next of kin, and if you couldn't locate them, you would be stuck taking care of the property that belonged to the tenant until such time as somebody came looking for them. The new law allows you to get the name of an emergency contact from the tenant and notify that person rather than the next of kin if the person passes away. Now, it should be noted that this statute only applies to tenants where then they're the sole tenant. If a tenant is married or has a roommate or other family member living in the property, this law would not apply. You would notify the other tenant in that case. But if there's a single tenant, then you can ask for an emergency contact and you would notify that person. Previously, the landlord would have to wait until an estate was opened up and then turn that property over to whoever was appointed to be the executor, if any. So sometimes it was a waiting game, and landlords were stuck holding property for 30 days, 60 days, 90 days until this process went through. And if you have a piece of real estate and you have the deceased person's furniture and other personal belongings in your property for 90 days, you're not able to turn it over to a new tenant. So that could be costly. Now, once you've notified the next of kin, you can inventory the property and file this inventory with the probate court, whether or not the next of kin open up an estate. And then when the next of kin contacts you, they can open the estate up and use the proper process to claim the property. In the meantime, you're able to store that property and dispose of it if no estate is opened up.
Okay, so let's just back up for a moment. So I'm a landlord. There's a single tenant in the apartment. The single tenant passes away.
Yes.
You're saying that now, if that happens, I can notify the next of kin, or
yes. Or that was the old law as well. The new law now allows you to appoint. Allows you to get, and you should have this in all your leases or at least on your rental application, their emergency contact. And now, instead of having to locate the next of kin, the law allows you to only notify this emergency contact.
And so I've notified the emergency contact. Are they required to do something specific, or I think you said inventory it and talk to the, well, continue.
Yeah, you would make an application to the housing court. All right, so here's the part that's difficult. Once a person passes away, you can't evict them because you can't serve them.
Okay.
So in order to remove their possessions from the property, you have to locate an executor or an administrator, because now they're the legal owner of the property. Now the probate court,
or the leasehold.
Right. Now you're not required to do that. You can make an application to the housing court without having a named tenant as a defendant. You can get an order from the housing court. Once you get that order, you can present it to a marshal, and they'll remove the property. But you have to do this process through the probate court first, so that you give the inventory of the property to the probate court, and then you'll get a certificate that you can submit to the housing court and get your execution without ever having to serve a notice to quit or serve an eviction action on an actual tenant or personal representative.
So based on the amount of time it takes today when you're doing a regular eviction, how long would you expect it to take the probate court? I guess first we do the probate court and then we go to housing court. I know that it hasn't been done yet because they just passed it, but how long do you think that would take?
Well, I mean, you're probably looking at probably 30 to 60 days at least for both courts to act. But that's still better than waiting until the next, because the next of kin may never open an estate. And now you're kind of in limbo because you have nobody to serve, but you can't dispose of the property because it's not legally yours.
Okay. And for Bridget, I'm not watching on Facebook, and the problem is that I've got an echo in my ear. And when I have an echo in my ear, we all talk very funny. So, Bridget, why don't you tell us what you do? Okay, I'm going to give Bridget a second to type something in, and I'll take it out of my ear while I'm not listening to anything. And unfortunately, the service that does the transcription is going to leave in all of this side chatter that I have here, where I'm talking about problems in my ear, and I'll have to edit that out. All right. So the original idea, Bridget, was Julie was going to come on. She was going to tell us who she was, what she does. I take these broadcasts and I put them on my website with a transcript. So since she's here and there's a transcript, that means that she gets a link to her own website. And links to your website from other sites are very useful because it helps with your search engine optimization. So that's why Julie is here, but we can't hear Julie. Wave, Julie. Okay, there we go. All right. Okay, Bridget, or Bridgetti, do you have Bridget, Bridgetti, do you have any questions to ask our guest, Kent? If you type them there, I'll put them up on the screen, and he can answer them. All right. I don't know if she's talking or not, or typing or not. But thank everybody for coming. Oh, okay. Here's a question for Kent. Kent?
Yes.
Yeah, after the law date is passed, how long does it take to execute the ejectment of the previous homeowner?
That varies from court to court, and it varies from municipality to municipality. So you should, in a very short period of time, if you file the motion for ejectment, that should be granted by the court within a week or two. And then you need to take that to a state marshal, who has to arrange with the municipality's Department of Social Services to protect that tenant, because now they're going to be homeless, or protect that prior homeowner. And that part of the process is very similar to the ejectment in a summary process case. So it might take a week again or two for the state marshal or sheriff, local sheriff, to execute the ejectment. So you're probably looking at anywhere from 2 to 4 weeks on average.
Okay. Kent, can you discuss the laws around breaking a lease? I have frequent questions about how a landlord or a corporate landlord can charge for lease breakage even if the property was rented. That's from Julie.
Okay, so I think what you're saying is you rent a property out to a tenant and they leave early. And so if that's the question, yes, I see you nodding. So it's different. The rule is different for commercial landlords and consumer tenants. If someone's using this as their personal residence and not transient living or a vacation home, the rule is different. And the law requires the landlord to use reasonable efforts to relet the premises. As long as they use reasonable efforts to relet the premises, the tenant is responsible for the entire lease term and or the difference between the rent obtained from the new tenant and the rent they agreed to pay. So it starts there. There's, the courts are reluctant to charge tenants or make tenants responsible, make residential tenants responsible for paying for rent when they're not using the property. But they also recognize what landlords have to do. There are a lot of lease provisions that you can put in, and of course that is something that would be merit a longer discussion. Some firms, some landlords will use buyout provisions or early termination provisions for liquidated damages. In other words, they'll write in a provision in a 1-year lease that a tenant can terminate that lease at any time with 60 days notice, provided they buy out the rest of the lease for 1 month's rent, and provided that they pay an early termination fee. So that prevents a tenant from terminating early, or discourages a tenant from terminating early. And as long as you can turn the property around in 60 days, you're covered for the 2 months that the property was vacant.
Okay, and Bridget says, wow, your processes are pretty fast. It takes much longer, and she's in South Africa. Just so you know, Bridget, how long it takes here depends on exactly where here is. We're in Connecticut. If we were in New York State, especially New York City, it could take easily 6 months or a year or more to get out a tenant. In Connecticut, I'm going to guess that and Kent, you can correct me, but from what I've seen, it's probably going to be somewhere between 6 months. I'm sorry, 6 weeks and maybe 2.5 months from when I start an eviction, or when rather an attorney starts an eviction, to when they'll actually get out. Is that correct?
Yeah, I would say the average is 6 to 8 weeks. It depends a lot upon the attorneys on each side. Housing court is a statutory process, so you really have to have an attorney who understands the technicalities. I make it a practice to represent both landlords and tenants, because I believe the best way to have a good offense is to also know the defense. And so in my practice, I have 2 records. My longest defense of an eviction was 3 years. I was able to keep the tenant in, and I got the case dismissed 6 times, and the landlord had to hire 3 different lawyers, and none of them could get the case right. I just had recently had one where the eviction was started a year ago, and the tenants just moved out last week. So those are the outside, and that's just because of the circumstance. Those were unique cases where the tenant actually claimed an interest in the property. So on average, if it's just a non-payment case, like Ed said, you're looking probably 6 weeks, 8 weeks, maybe 3 months at the outside. And if it's taking a long time, there are some measures that you can take to get the trial moved up more quickly. There's a motion called a motion for use and occupancy payments that can be filed with the complaint. And if it's not responded to right away, the court will set a trial date. And if it is responded to, the response that the tenant has to make is to start making payments, or it'll go to trial.
Okay, so oh, go ahead. Were you finished?
No, I was just saying it's a good tool to use, the motion for payments.
Okay, so Fernando Diaz says with a lease purchase, he has 2 agreements, lease and option. The option agreement has a small rent credit. Is there a certain limit or percentage that I want to avoid in order to prevent the tenant making an equitable interest in the property? In that case, I can't do an eviction and have to do a foreclosure. I don't think that you're going to need with a lease to purchase. I don't think is that a lease with an option you're talking about, Fernando? You know what I'd like to do, Fernando, was if you'd like to come on, I think that I can, if you give me a sec, I'm going to disappear from here, and I'm going to text you a link, and you can come on here and ask the question yourself. So why don't you guys just give me a second, and I'll be right back. I'd say talk among yourself, but Julie doesn't speak much.
We can chat.
Okay, so the problem is that I can't talk. I can't chat. Oh, maybe I can make a comment. Yes, I can make a comment. Hold on a second. Let me figure out what I'm going to say here. I got to find the bit.ly, and Okay, Fernando, if you can see that, let's see if it came out. Yes, it did. So, Fernando, if you can see that, if you click on that, you could join us and speak. So just click on the link. If if you're using a phone, it's going to ask you to download an app. If you're using your computer, you have to be using Chrome. So why don't we speak a little while you're while you're getting here? And I guess the question was about lease option. If somebody has a lease option, and Kent, you can tell me if this is correct. He's worried that he'd have to foreclose somebody who has a lease option, and you can tell me if I'm wrong. But I think that what he'd do if somebody defaulted on the lease, it's just a regular eviction, and they lose the option depending on how it's written. Go ahead,
Well,
Kent.
You're exactly right. It depends upon how it's written. And so this is one of those things where the drafting of the documents are critical. And I wouldn't be able to comment on on Ferdinand's question without seeing the documents he's using. But he's correct. If you're giving principal as part of your lease option, then the renting party is acquiring an equitable interest in the premises. So while you may be able to remove them from possession, they may still be able to claim equity in the property, and that can only be foreclosed in a foreclosure process. So there's a better way. The better way to do a lease option is just to give an agreed upon price that will hold up in the future, and that's where the benefit of the bargain comes in. So if you know a property today is selling for $200,000 and you want to give somebody a benefit, then you could say, well, I'll tell you what, if you buy the property after 2 years, or I should say after a year, if you buy the property after a year of successfully renting it, then I'll let you have it at the market price, the price I'm listing it to, the listing price minus what the commission would have been, and that price will be good for a year. And so in exercising the option in the future, they've saved money on the purchase of the property. So if it's a $200,000 property, you tell them, well, you know, I would have had to pay a realtor anyway, so I'm going to take $10,000 off the price, 5% of $200,000, and you can buy it for $190 in 1 year, and we won't use a realtor, and that'll be your savings. That way, they don't have an equitable interest in the property; they just have an option to buy it at a future price.
Okay, but let's make sure we use a realtor, right, Julie? Okay, that was supposed to be funny. Anyway, all right. So Julie is asking, can you explain how landlords can't accept prepaid rent in exchange for reduced rent? So how many months of rent can we accept, Kent? And I think we talked about some magic number of 62 years old.
Yes. Well, the answer to this question is not where you'd expect to find it. It's actually in the security deposit statute, not in the landlord-tenant statutes. And the security deposit defines security deposit as any amount of rent collected more than 30 days in advance, except for the first month's rent. And that is called a security deposit. Many people use the term first and last month's rent and 1 month security. Those terms are misleading. There's no such thing in Connecticut as last month's rent. And you're doing yourself, as a landlord, you're doing yourself a disservice by calling it that, because it encourages tenants to leave without paying the last month's rent. Now you're only left with 1 month's security. If you call it a 2 month security deposit, that's what the law calls it. And now you are not allowed to use that until the tenants move out of the property. And if they don't pay the last month's rent, you serve them with a notice to quit, just in case. It's most local sheriffs, some state marshals will charge you a very reasonable amount of money, and most landlords can draft their own notice to quit. So the short answer to your question is a security deposit is defined as any amount of money collected prior to the first month's rent, more than 30 days in advance. And that a security deposit is limited to 2 months rent. And that's why you can't collect prepaid rent at all, except for the first month.
Okay, hold on a sec. Let me get to the right page here. I was trying to get Fernando that information so he could come on here too. So do we have any other questions? Julie, no, you don't. And what would be nice is if this interface had a little bell when somebody gave a comment, so I'd know that they gave a comment. So let me see.
If I can elaborate a little more on
what else do we have here? Here, okay. And Julie, I see that you posted the you posted where they can find some of the landlord law. Can you post the link that you use to get here? Because you seem to be able to post even if I can't. Okay. So Fernando, you could try joining us if you like. Julie, you'll wave to me when you posted that. Okay. So Fernando, if you take a look at I see you're waving. Yes. So Fernando, if you take a look at the comments, you're a great assistant, Julie. Wonderful. Maybe Fernando will be joining us, and maybe Fernando isn't I don't know about 8. Whoops. We seem to have lost. There he is. Hold on.
Sorry about that.
You disappeared?
Yep, I disappeared just for a moment.
Okay.
I clicked the wrong button.
Oh, all right. Now, I'm not sure. Fernando, can you see the link that Julie posted? All right. There are 2 places that you could post, Julie. One of the places you posted, you said, Jim, you can see a lot of information here, but that wasn't in the team chat. That was commenting. I'm not sure how you commented differently. Yes, we're trying something new today, and we haven't been on this before. So please forgive us if we're not, if we don't have know how everything works. All right. If there's no more questions, let me just take a look here and see if there are. Yes, Julie, we make a great team. And for some reason, I see that you printed that, but I don't see the link there in the same place. And I don't know why. Okay. Thank you, Bridget. I guess we're done here. So just so people know, we typically meet on the first and third Thursday at 7:00. Up until now, all of my interviews have been on a conference call with a telephone. And we've tried something new today where we're doing this on Facebook Live, so you can see us and hear us. Following this broadcast within the next couple of days, I'm going to get this transcribed, and you can find it on www.ctreinvestors.com. You can join our group on Facebook, which is the group CTRE Investors. And we also have a meetup on meetup.com, also called CTRE Investors. because of the Christmas season, I don't think we're going to have a second interview this month. And the interview next month might not be the first Thursday rather. It might be the second Thursday. So I'd like to thank everybody from coming here. Thank you very much, Kent. Thank you, Julie, for handling some of this back end stuff for me. And we'll catch you again next month.
Okay, thank you, Ed.
Thanks again, Kent. Everybody have a nice night.